In my time before the court, I will tell you how a dog sniff at the home front door of a residence is a search within the Fourth Amendment because it is trespassing. There is no implied consent for the officer to be there, and within the historical context of searches, it is a search. As established in Oliver versus U.S., the front step of a house is the curtilage. So by being there, the officer is already trespassing. Now, by having the dog, he is not within implied consent, which goes hand in hand with trespassing. Had he been just by himself using his own senses or just there to do a knock and talk, it would be different. Or if he was a neighbor or a regular citizen, it would be different because it really comes down to the relationship between the person and the people involved.
So you think that a neighbor coming up with a dog with the intent to search would be different than an officer coming up with a dog with the intent to search because of their past relationship?
No, it depends on what their intentions are. The dog's only intention is to search for drugs, so if they bring that dog up with the intention to determine the presence of drugs within the home, then they are, there is no implied consent for them to be there and they're trespassing. And a police officer with a drug detection dog is also just there with that one purpose to detect drugs within the home that otherwise he would not be able to, he would not know about. So that one purpose of detecting someone in the home that otherwise would be unknown makes this a search. Because without the dog's sniff, which is beyond human capacity to smell, they would not know that the drugs are present.
Well, it's my belief that the dog is smelling the presence of the odor, not specifically that contraband is present.
Well, that is true, but the odor means that either contraband is present or recently was present, which means that either way, illegal practices are going on. Did I just argue the wrong side?
Well, thank you. Next case. Just kidding.
Sorry.
That's all right.
So, wait, give me a second. By sniffing and guaranteeing that, I was so far off. By the sniff is a search no matter what because it's detecting where the odor is coming from the home, something within the home. They are trying to find something within the home, which by with that intention in mind, the intention of finding something within the home, albeit they're detecting the odor outside the home, they are really looking at what would be within the home and what is therefore deemed has a reasonable expectation of privacy.
Well, I thought you didn't have a reasonable expectation of privacy to contraband, though.
That's because it's illegal, but in cats, although what was being discussed was illegal, it was deemed a search because the police's way of getting the information was not legal, as it was in this case, by trespassing and by without getting a warrant before sniffing the residence. They are searching the residence, and it's the way that it's carried out is not legal, and it would be conducted as a search because of how they're doing it, not by what is being searched, not what they're searching for.
But I thought cats was different because it was you listened to the whole phone conversation, so there was plenty of legitimate information that could have been obtained from that. But this only detects contraband. That's
true, but in that case they kept reassuring that they were only listening to this person detecting what he was talking about, which they were pretty certain was illegal, and yet they still determined in the end with this reassurance that all they heard was illegal information, that it was a search because of how they carried out the censoring of information and how they obtained their information by listening in on what was held to be was an area with a reasonable expectation of privacy.
So to go off of it, so do you think there was a legitimate expectation of privacy in contraband?
It depends on how the search is carried out. So if they have a warrant and they're finding the contraband with the warrant because they would have had probable cause to get the warrant, then there's no implied, or it's not, what's the word, it's not legal to have them, or it's there's no implied privacy of having them. That does not make any sense.
Sorry. Take your time.
So there is no implied consent of privacy with drugs, but the way in this case that they were carrying out the search for it was a search, and it was the problem here, that they didn't carry out the search the correct way.
What should have been the correct way? Just getting a warrant?
Yeah, because they observed the residence for a period of time before they actually got a warrant, before they even approached the house. If they had approached the house without the dog first, if he went up and knocked on the door and maybe waited for someone to answer, or just from then on went back to get a warrant or to get a dog, that would have been the correct way to carry this out.
Okay. And to clarify, you think placing cabellas, like in neighborhood that dog sniffs were okay, but you think this is different because of the house, right?
Yeah, because you don't need a warrant to search a car. And also looking at the historical context of what the Fourth Amendment meant when it was adopted, it protected everything within the home. There was no exclusion like pointing to drugs or any other illicit materials. So by detecting the drugs within the home and doing it with means beyond human capabilities, they are searching the home. Are there any?
Do you have the citation for like where that quote was from?
It was in the brief page.
So at the end of the day, you're saying the dog is illegally trespassing on the property, as well as the dog's sniff isn't reliable enough to lead to probable cause.
Yes. Because his being there in the first place is trespass, because there's no implied consent, and also because the doorstep is within the curtilage of the home. And his lack of reliability, although not as relevant in this part of the case, it is still a problem that he is not as reliable as other means, or that he is the only means that they're using to search this home, and that he is like using senses beyond that of human capabilities to determine whether or not there are drugs in the home. So
if we ruled that in the car situation that it was an illegal search, would we have to rule in your situation that yours was also an illegal search?
No. Yes, because they're using the same dog and the same reliability issue.
I was going more to the they obtained evidence illegally.
Well, so you're asking whether or not if the car search is deemed a search or not a search?
Yeah, if we say that the car is an illegal search, that they aren't allowed to use the dog, we automatically have to say in your situation that it was illegal as well?
Yes, because there's often, it's like, it takes less to search a car than it takes to search a house. So if you're saying that there isn't enough information to search the car in this case, or the dog is not enough reason to search the car, then it's most definitely not enough to search a house. Because
I want to go more back to where did we get the idea to search the house, or to conduct the dog sniff?
From the envelope within Giacomo's car, I believe.
Alright, so if that evidence is considered illegal, then we have no reason to search your house either, right? Do you understand what I'm saying?
Yeah.
Alright.
Like, there was no reason in the first place to search the house.
There's a quote that I'm sure your counsel will share with you about fruits of a poisonous tree that you might want to look into.
Okay.
It's kind of important for the argument.
Okay. Do you know where that is?
I'm sure I specifically don't remember exactly what case it's mentioned in, but we can't talk to her until the end of your time is up, unfortunately.
Page 21.
But back to what were you asking a question about? It just.
I think it might be important for you. To back up your case would be to say that, I mean, the evidence was illegally obtained in this first situation, so they had no probable cause to even search your house.
Okay, got you. So because the way that they obtained the information from the envelope was not, like, because it was illegal, they didn't have the reason to search the house because it was obtained with illegal means.
Or to even approach the house.
Yeah, because it wasn't enough probable cause. Just an envelope with an address is not enough probable cause, and it's being got by illegal means is not enough. Makes it not okay to search the house.
So you think if Giacomo wins, then Sabling also wins?
Yes.
Interesting.
And does it go the reverse? If we rule that in her situation that it is a search, it's not an illegal search, do we have to say that your situation's not an illegal search as well?
No, because as I was saying before, the search of a house is different than the search of a car. It takes more to search a house. Like, you have to have a warrant to search a house. You don't have to have a warrant to search a car, and it takes more probable cause to search a house because that is where people have, through time, felt more safe, and there's been more expectation of privacy.
Thank you.
Okay, we request that you uphold the lower court decision.
Thank you. Petitioner, you may proceed to the podium when ready for your 3-minute rebuttal.